Greetings, folks. Happy Sunday afternoon. I think that many of you, if you have been paying attention, if you're on planet Earth and you are impacted or have friends or family impacted by the Presidential Proclamation of September 19th that came out late Friday, you probably have, lost sleep, which I don't blame you, and are quite confused or maybe just anxious about what has taken place. And I think that for us, we have certainly, been paying close attention to what's been going on. We've been in discussions with folks about, best moves to make, including people who were, overseas at the time that this took place and are, continuing to advise folks accordingly. So those of you who might not be as up to date with everything, this, started on Friday, and I'm just going to show a clip really quick.
I think, Sean, do you agree with that?
Well, they're $100,000 per year. So the whole idea is no more will these big tech companies or other big companies train foreign workers. They have to pay the government $100,000, then they have to pay the employee. So it's just not economic. If you're going to train somebody, you're going to train one of the recent graduates from one of the great universities.
So he said $100,000 per year, and the proclamation itself also confirms this.
Across our land, train Americans, stop bringing in people to take our jobs. That's the policy here. $100,000 a year for H-1B.
He said it again.
H-1B visas, and all of the big companies are on board. We've spoken to them about the gold card.
They love it. They love it.
Renewals, first times. The company needs to decide, do they want, is that person
renewals and first time
valuable enough to have $100,000 a year payment to the government, or they should head home.
Third time, he said $100,000 per year.
And they should go hire an American. The whole idea, it's annual, and it's for total.
Fourth time, he said, it's annual.
It can be a total of 6 years. So $100,000 a year. So either the person is very valuable to the company and America, or they're going to depart and the company's going to hire an American. And that's the point of immigration.
I think, Sean, do you agree with that?
Well,
so clearly that was the message that went out on Friday, and as expected. And one of the reasons why we didn't react, so immediately is, as has been the case with Trump, in many instances, whether it's been, certain foreign policy decisions, executive orders, tariffs, he tends to put out some extreme policy and then they start to reverse it. So in the situation where, there is some major situation, we always want to make sure we have the correct information before sharing that with you. So this Axios article, I think, does do a really good job of summarizing what has happened thus far. And here it says that, the headline is that new H-1B visa fee will not apply to existing holders. I'm gonna caveat that a bit in a minute, but let's just go through the information first and then I'll explain. So it says a new $100,000 fee for H-1B visas goes into effect Sunday, but it will not be applied to existing holders of valid visas re-entering the country, a White House official tells Axios. Now, this arises from the abhorrent situation that many people were facing with not knowing whether or not they would be allowed back into the United States after taking a short trip abroad. So, those individuals who, and many of our clients, may have, for example, just attended a wedding or a funeral or visited family or maybe on a business trip, and there was a lot of fear about what was going to happen in that respect. So I think that, it was a major issue that we needed to be concerned with. So that was, one of the things that we were, looking at and making sure that we had right before we sort of go into this, situation. So the Axios article then goes on, and it states here that so let's just see where we are with the Axios situation. Sorry, I'm just having a little technical issue. So Friday night, Trump signed an order requiring H-1B holder or their corporate sponsor to pay an annual, right? We heard it 6 times by Lutnick, the Commerce Secretary. 6 times he said it. Annual. Pay an annual $100,000 fee for their visa. So, and it talks about tech companies, could potentially mean a new fee of $100 billion a year. So this rule and the cruel part of this, and I use the word cruel in, I think, accurately. Some attorney friends of mine said I'm going overboard by using the word cruel, but I think this is cruel. The cruel part about this was that the rule was set to kick in at 12:01 a.m. Sunday, right? So that would have been midnight last night, essentially. And for those, again, who were outside of the U.S., who were, people were scrambling. There were situations in SFO, in Washington, and other airports where people were running off of flights that were about to take off because the news broke as they were, starting to leave the country, or having already, been in a terminal waiting to board their airplane. This is insane. This is not the way that America behaves as a nation. We don't treat people like this. This is a period that, is going to be looked upon in the future as a dark day in American history. I'm very, very sure of that. The next thing it says, so it starts talking about tech companies, and this is regardless of what people's position is on immigration and what you think about the H-1B situation. The way you do things matters, and the way you implement policy matters. These are people's lives. These are people who've been in the country for 10 years. Some people have, their kids in sports, and, these are your neighbors. These are your friends. So for people to just, completely lose all of their dignity and have to drop their suitcases and their luggages on the way to India, and they're rushing back home because of this kind of policy being abruptly and thoughtlessly laid out, is absolutely and totally ridiculous. So the next issue is so then it goes on to say, so it lays out this horrible policy, right? And here's the actual proclamation, and it talks about all of the reasoning that, from the administration's perspective. And then it says, accordingly, by authority vested in me as president of the Constitution of the United States, restriction on entry pursuant to the sections cited. The entry into the United States of aliens as non-immigrants to perform services in specialty occupation under H-1B is restricted, except for those aliens whose petitions are accompanied by a payment of $100,000, subject to the exceptions set forth in C. The restriction shall expire 12 months after the effective date. And then it says, Secretary of Homeland Security shall restrict decisions on petitions not accompanied by $100,000 payment for H-1B specialty occupation workers, and so on and so forth. And I'm going to get into what this means for those who are thinking about H-1B transfers. So that's, stay tuned for that. So then we go on and we say, okay, it talks about the compliance and what employers shall, prior to filing an H-1B petition on behalf of an alien outside the U.S., obtain payment showing the $100,000, so on and so forth. So clearly, this is, a very harshly written, probably, Stephen Miller written proclamation. And, this was, let's see, Friday afternoon, and then the spokesperson for the president has since said, this is Carolyn Levitt, so she's the press secretary of Donald Trump. She said, quote, "This is not an annual fee." I just played Levitt's remarks. He said 6 times in 1 minute, 6 times he said it's an annual fee. She's saying it's not an annual fee. Those who already hold H-1B visas and are currently outside of the U.S. will not be charged $100,000 to re-enter. And then H-1B visa holders can leave and re-enter the country to the same extent they normally would. Whatever ability they have to do that is not impacted by yesterday's proclamation. This applies only to new visas, not renewals, and not current visa holders. So again, Lutnick mentioned renewals 10 times in his comments. So we're supposed to ignore that, I suppose. And even right here, I think the X community said right here, Lutnick repeatedly said in Oval Office briefing, this was an annual fee. He said it 6 times. So, and then, you know, there's some other articles that the White House had said that corporate lawyers and others with agendas are creating a lot of fake news around the proclamation. And I think this is referring to the various, you know, comments that were made by folks, including myself, telling people not to travel and not to, and if you are outside of the U.S., that you need to, you know, get back as soon as possible. So that's sort of where we are in the situation. And I would say that this is extremely problematic. I mean, there's no way to go mince words about this. I think when we think about the, you know, proclamation itself, okay, one more thing. So now USCIS issued a memorandum yesterday that attempted to clarify the restrictions around the proclamation. So let me read it to you. On September 19th, 2025, the president issued a proclamation restriction on entry of certain non-immigrant workers to address systemic abuse of H-1B non-immigrant visas. Pursuant to the applicable sections, the entry into the United States of aliens as non-immigrants to perform services of specialty occupation under H-1B is restricted except for those aliens whose petitions are accompanied or supplemented by a payment of $100,000. This guidance applies to H-1B employment-based petitions filed after 12 a.m. Eastern, 12:01 a.m. Eastern on September. So that's the attempted clarification. The last sentence right here says, this guidance applies to H-1B employment-based petitions filed after 12:01 a.m. Eastern on September 1st, 2025. And then it says, in bold, this proclamation only applies prospectively to petitions that have not yet been filed. The proclamation does not apply to aliens who are the beneficiaries of petitions that were filed prior to the effective date of this proclamation, are the beneficiaries of currently approved petitions, or are in possession of validly issued H-1B non-immigrant visas. All right. So if you're in any of those 3 categories, it's saying the proclamation does not apply to beneficiaries of petitions that were filed prior to the effective date, right? Approved petitions or in possession of validly issued H-1B visas. All officers of United States Citizenship Immigration Service shall ensure that their decisions are consistent with the guidance. The proclamation does not impact the ability of any current visa holder to travel from the United States, right? That's what they're saying. Now, what we need to understand, folks, is that the information that's coming out of the administration is not consistent, nor is it to be relied upon as a matter of law. The 2 documents that are of actual effect at this point are the proclamation itself and then the USCIS guidance that came out subject to the proclamation, which is the memorandum. And they do have contradicting terms. But as far as the implementation or impact upon you as an H-1B holder or your family member as an H-1B holder in the United States, the memorandum is going to be what applies. Because the way this works is an executive, like the President of the United States, issues a proclamation or an executive order, and then it's up to the bureaucracy, it's up to the actual bureaucratic department responsible to implement that executive order. So the implementation of the executive order takes place by the Department of Homeland Security and the Department of State. As it relates to individuals who are already in the United States, we're talking about the Department of Homeland Security. As it relates to individuals who are outside of the United States, we're talking about the Department of State. From everything that we can tell, since particularly since yesterday, it appears that those who are outside of the United States who have an already issued H-1B visa or even a approved petition for H-1B that predates the September 20th, 12:01 a.m. Deadline are not going to be assessed the $100,000 fee as far as the implementation of the order. Now, that is independent of the fact that the order is problematic, right? So let's not, kind of be too cozy or comfortable with this, situation, right? So I think that we need to be kind of balanced in our approach to say that the proclamation itself does call for an annual fee. The proclamation itself does clearly state that individuals who are outside the United States would need to pay the $100,000 fee before coming back. But the implementation of the proclamation is such that they will not hold that rule upon individuals who have already been issued H-1B visas or have been issued H-1B visas prior to September 20th. So this is sort of a 180 that they're doing. And probably because of pressure from, the, tech company, leadership and, phone calls that were made and such. So having said all of this, it's not good news. I mean, any way you cut it, it's not a good situation. It's going to be a difficult period that we're entering. And I want to also make a point here to state that when we think of H-1B transfers, we use that terminology loosely at times, right? Whether it's an attorney or I think, in the community of folks who work in the industry, we use the term H-1B transfer as if it's a foregone conclusion that I'm simply transferring my visa from one company to another, like but that's not really the case. When one files or when one changes employers while on an H-1B visa, it is a new application, right? They are filing an I-129 with the H supplement. Now, they're already cleared of the lottery situation, but I am not sure how this is going to work. I think that according to the proclamation, according to everything that we're seeing, H-1B transfers will be subject to the $100,000 fee. Now, whether that fee is going to be one-time application fee or an annual fee, I mean, we don't know. The proclamation says annual fee. The Lutnick said annual fee. The statement from the press secretary said it's not an annual fee. We don't really know the situation. What we do know is it's much worse than it was before the proclamation was made. I tend to think that those of you who are in the U.S. who are working successfully and are living on an H-1B should start to think about taking matters into their own hands, right? I've talked about this many, many times, and mostly I'm concerned with the way corporations treat their employees and how being subject to the restrictions that come with an H-1B limits one's ability to pursue their dreams, if you will, or to start businesses or to create a startup and what have you. So those are the concerns I've always had. Now we have, I think, another level of concern, which is the government is after you, and they are seeking to restrict and impact. I mean, if you read the preamble of the proclamation, it is quite harsh in its assessment of STEM workers in particular. With it, I think they're unfounded claims. They're claims that are presented by people who have a ideological agenda here and have nothing to do with actual the interests of the economy or the country. So this is beyond an economic issue. This is a ideological agenda that's driven by folks who tend to think that this nation only belongs to one particular group, and history has shown that this sort of tendency arises from time to time in throughout American history, and it's defeated time and time again. So I'm confident that that will certainly happen in the future. Now, the question is, what do we do now? For those of you who are in the situation, what options exist, and how can we go about solving or liberating ourselves of the shackles of the uncertainty surrounding the H-1B and the future that is not good. So before I get into what I think are some good solutions, I just want to make a comment about the Trump quote unquote gold card. So it's unclear so far what the regulations will be. It's also a fact that on his own, the administration cannot create a completely new category of immigration. So it's very, very precarious for one to, put their life savings into something that would probably not stand the test of time. So I would be extremely cautious about that approach unless it goes through Congress and is created as a new, a category, or is adopted into an existing category like the EB-5, for example. I would stay far away from that. There is a website that, the White House put up, and it seems to just be collecting data from people interested. But again, a new category of immigration must go through Congress and become a law. You cannot just sort of, as an executive, that's not the way things work in the US. You can't just create a new category by a stroke of a pen. There is a process. There's three branches of government, right? There's the legislative branch, there's the courts, and then there's the executive branch. So we are, witnessing a period where the executive branch is trying to sort of go beyond its powers. Now, I've certainly, there is significant power for the executive, right? And where his power is most impactful on its own is through the State Department and restricting entry upon people abroad. For those who are in the United States, at the end of the day, you still have due process of law. So I would see that there's going to be a lot of lawsuits related to this proposed fee, for the H-1B. There would be a lot of lawsuits for those who are restricted from coming in from outside as well. But, I think that for the most part, what we're going to be thinking about is the, situation where, the vast majority of people are, impacted by this are going to be in the US, and you should have, recourse. And we're looking into those different, recourse. So now, again, if you are in a situation where you've been living on an H-1B, you've been in the US probably for, 3, 4, 5, 10 years even, and you might have a existing I-140 that's in a visa backlog. The problem that this proclamation is creating for you, in my view, is it creates an uncertainty as it relates to travel abroad. I'm not saying that in all instances one should not travel right now, but probably you should wait. But it is creating uncertainty. We know that for sure. It is also of great, great concern that the ability to transfer from one employer to another is going to be almost highly restricted or become nearly impossible for many people, right? So it's going to be, I think the better word than impossible is impractical, right? It's going to become impractical to change from one employer to another because of the $100,000 fee. And we don't even know, like, because a company, I mean, they may want to acquire the talent and ability of someone to, such a degree that they're willing to pay the $100,000 fee, but they have no guarantee that the person's going to stay with the company. They have no guarantee that they're not going to have to pay the $100,000 fee again after 12 months. They have no guarantee that the person's going to be able to re-enter the United States after a short trip abroad. So there's a lot of issues there. Now, where I think we can solve this problem, or one such idea I think that is going to emerge, and we've been doing this for a very long time. I've done this hundreds of times for people over the years, and that is to, rather than depend on an H-1B visa, if you're a highly skilled individual, if you have already developed, advanced technology within your, profession, and you feel really good about the achievements that you have made, I would say that you might want to talk to your HR, talk to your employer, or think about, joining a new employer under an O-1A visa. An O-1A visa is a non-immigrant category for individuals who have extraordinary ability. And the requirements for an O-1A visa are almost similar to the EB-1A. They're not that unsimilar. There is a lot of overlap between the the O-1A and the EB-1A. So I think that it will be an area where I think we look to for a lot of support, and allowing people to to enter. So if we're looking at O-1A, let me just walk you all through what that might look like if I can figure out how to use my system here. All right, there we go. So this is the USCIS policy manual on the O-1A visa, right? And when you look at the O-1A visa, you need to demonstrate that you meet a minimum of 3 of 10 requirements that are laid out, right? So you have to satisfy at least 3 of the following evidentiary requirements. And those of you who are familiar with the EB-1A, they roughly align with the EB-1A, except that the requirements are a little bit less heavily scrutinized. They allow for a little bit greater flexibility. They're not as strict as some of the other areas. So, for example, here it gives IEEE level as an example of what actually qualifies for membership criteria under O-1A, whereas sometimes in an EB-1A you might not see that level of flexibility. Also, it deals with, for example, various membership categories, original contribution of major significance, authorship of public articles. Now, here's where there's a little bit of a difference. So it talks about evidence that the beneficiary has been employed in a critical or essential capacity, whereas the EB-1A talks about being employed in a critical or leading capacity. So that is a little bit different of an evidentiary and requirement. And we look at obviously salary and other considerations as well. Now, why do I think that the O-1A is a pathway out of this mess? Because there is a very, very important provision within the USCIS guidance as it relates to EB-1A. So if we look at the EB-1A requirements under the very, very bottom here, if I can get to it, it states, and here we go, right here, evaluating immigration petitions filed on behalf of O-1 non-immigrants. So within the EB-1A adjudication process, there is a scenario where an individual who is applying for EB-1A after already having received an O-1A is at an advantage or a relative advantage as it relates to the regulatory criteria, right? So you're not as restricted as you, or you're not as heavily scrutinized as you would be if you're applying without an O1A. So let me explain why. It says here, an officer might encounter a case where a petition, so we're talking about an EB1A petition. So if an EB1A petition is filed, an adjudicator, an officer of USCIS might run into a scenario for a petition filed on behalf of a person who was previously classified as an O1 non-immigrant with extraordinary ability, right? So here's where it's important. It says the approval of an O1 petition is a relevant consideration and can be an indicator of eligibility in adjudicating an immigrant petition for persons with extraordinary ability. Let me repeat that. The prior approval of an O1 petition, meaning an O1A petition, is a relevant consideration and can be an indicator of eligibility in adjudicating an immigrant petition for a person with extraordinary ability, although it is not determinative, right? Now, it says here, due to the similarities, some courts have asked USCIS to provide an explanation as to why, if the person had previously been classified in almost the same similar category, USCIS has determined that the person is not eligible for employment-based immigration visa qualification. What this means is the courts have told USCIS, dear USCIS, if you have already approved a person in an extraordinary ability category, such as O1A, why in the hell would you deny them an EB1A visa, right? And if you are doing that, we want you to explain the reasoning why you're diverging away from a previously reached opinion, all right? And this is really super important because essentially USCIS adjudicator is not going to want to oppose a previously reached decision unless there's a very big reason why. So part of the strategy that I am advocating here is to consider a transfer from H-1B to O1A as a step one toward ultimate green card. Because when you have an O1A that's been secure, it then creates a presumption, as I've shown you here right now, that you also qualify for EB1A. And that will be the ultimate success, is to get the EB1A approved and not have to worry about the mess that we have as it relates to the H-1B. Notwithstanding the changes that might occur, the court decisions that might block the proclamation, and so on and so forth. So ultimately, this is a huge wake-up call for the community. You are in a situation where you are among the most vulnerable class of immigrants present in the United States. You're on a temporary worker visa that is being targeted by the government as something that they view to be interfering or impacting the ability of U.S. citizen workers to gain employment, which we all know is BS. And it's also a situation where we have, a potential huge fees that are going to be arising as it relates to this category. Particularly concerning is the limitation on whether one may transfer their H-1B from one employer to another. This now becomes a serious issue. I mean, this could even arise like in a merger or acquisition situation, right? Where your H-1B has to be transferred to a subsequent company. So there are so many scenarios where living and working on H-1B subject to this proclamation is going to become a nightmare. And I urge all of you to consider the situation very carefully, to think about what options might exist such that we can overcome this issue, because I believe that living under the restrictions that are being put in place by this White House is not a way to be confident about your future presence in the U.S. So I think that this is going to be very, very important to our community and important to our friends and neighbors. So question here from Abhishek Mishra. He says, does ONA also has priority date requirement, and would I-140 priority link with ONA? So ONA is a non-immigrant category. All right. It's actually a dual intent non-immigrant visa, meaning one may use an ONA with ultimate immigrant intent, but itself, it is not a immigrant category, meaning you are a non-immigrant working and living on the ONA. So the ONA has no priority date requirement because it's a non-immigrant. It's not a green card application. So that is something that we, know very clearly. However, when you go to apply for a green card after having, in like an EB1A category, after an approved ONA, at that point, you would be subject to priority date as it relates to the, a green card situation. And I think, obviously there was some movement in the October bulletin as it related to EB2 and EB1 India and EB2 NIW for, non-Indians. But that is something that, is going to be, consideration. So just so you understand that, Mishra, what we have now is a situation where you can move from your H-1B to an ONA without restriction on numerical availability. However, when you ultimately apply for a green card, you're still subject to the same priority date that you would have subject to your I-140. If you have a previously approved I-140, we can port that date to the new I-140, but you're still subject to that restriction. One much bigger issue with the ONA and reason why I've, hesitated at times to use it is because unlike the H-1B, when one has a H-1B with the I-140 previously approved, many of you know and benefit from the fact that the spouse would be able to work under a H-4 EAD. Under O1A, there is no employment ability, or there's no employment authorization for the spouse, right? Your derivative spouse is not given an EAD. So anybody who is on an O1A, we need to figure out a different, the spouse can live and, in the US as a derivative of the ONA on O3, but they are not able to work under the O3, right? So that does become a problem, obviously, for folks out there whose, obviously spouses work in that category. So that's the main issue with ONA. But ultimately, I think it is still a really good step in the right direction because it puts you in an advantageous position to apply for EB1A. Obviously, you can apply for EB1A on an H-1B. You don't have to go to ONA first. The reason why I'm saying that this might be a good option is because it creates a presumption. So if you're like a borderline EB1A case, it's a good option to do ONA because then you have a presumption that's under the law that you also qualify as an EB1A candidate. So that's why I think it's a better way to go about doing this. I think I would consider the fact I think it's like, I don't want to give specific advice. Obviously, this is for educational purposes. But another question I receive is whether I would advise a person who's on an H-1B with 3 more years, to switch to O1. It depends on the specific fact pattern. It depends on your profile. It depends on whether we can lay out a plausible ONA and ultimately EB1A case for you. So I would consider it as part of a comprehensive strategy to get you off of the uncertainty of living on non-immigrant visas. See, I think that there is always a tendency in the Indian community to look for a fast solution to everything. And I get it. It's you live with anxiety and uncertainty and, you know, such. My approach has always been to be very thoughtful about every situation. In fact, that's why we started Silmi Law, is because we felt that this idea of immigration law firms being sort of conveyor belts of cases was problematic. I never liked that. You know, like I've seen firms, they do, you know, thousands of H-1B cases and nobody pays attention to the facts or the issues. And what I did about 10 years ago was starting to pluck some of those profiles from a business related contributor perspective and move them out of EB2 and EB3 backlog categories and put them into EB1A. So what I'm about is going deep and thoroughly and analyzing a particular individual's case and finding an all above pattern to ultimately solve their immigration problems once and for all. That's what we're about. We're not about cookie cutter. We're not about paper pushing. We're not about thinking about like temporary, you know, situations only. We're thinking about how do we solve a problem once and for all. So that's the name of the game, is making sure that we have a comprehensive, thoughtful approach that's deeply strategic and puts you in a position to be successful. So that's what our history has been as a law firm, and that's what our future is going to be. Is we're going to be all about thinking in terms of you know, moving the situation forward and putting you in a comfortable situation where you don't have to worry about these sorts of scenarios. Because I hate to tell you, but like JD Vance is probably even worse in terms of openness to immigration than Trump. So like if the powers that be remain in place beyond, that assumes Trump's actually going to leave office, by the way. But if the powers that be remain in, you know, if you're thinking, let me just put my head under the sand, stay quiet, not do anything for the next couple of years, this whole thing goes away, and then I'll worry about my immigration situation after this administration, you know, is out of power. There's at least a 50-50 chance that it's going to get worse. Hopefully that doesn't happen, right? Like I'm definitely on the other side of this. So I find these folks to be totally, you know, I think void of their, you know, acceptance of the equality and common good of humanity. You know, I feel like we are all, you know, created equally, and we are all, you know, here because it's our destiny to be here. And, you know, people who've, you know, immigrated to this country have great contributions that they're making to the you know, economy, to society. I mean, like, I don't want to just eat like cheese pizza the rest of my life. I mean, I like the fact that we have immigrant communities where, you know, we get to share our culture with others, right? I happen to also have a restaurant that I own as a, you know, kind of a side investment. And I feel it's a beautiful thing. I get to share my Palestinian culture with the neighborhood around us. I feel like, you know, same thing for, you know, whether it's Indian food or Chinese food or, you know, West African cuisine. There's a Senegalese restaurant that recently opened in my home city that is delicious and wonderful. So like, we're not, and if you look at the history of the US, not to bore you all, but like there's always been an anti-immigrant, you know, a sentiment. And I think that it's always overcome as well. I mean, you know, this happened actually to the Irish when they came in the early 20th century. It happened with Jewish immigrants. It happened with even the Italians. I mean, I actually have a old barber. I grew up in the Bay Area in San Francisco, and one of my when I had hair, one of my barbers was Italian, an old Italian man. And he told me that there was a time where the government came and shut down all of the Italian-owned businesses in the East Bay because of the basically, World War II and fascism and Mussolini and what was happening at the time. So, it doesn't surprise me that there was sort of a breakdown in relations and sort of a fight over tariffs as it relates to the India US relationship and whether they're buying oil from Russia, so on and so forth. And then this comes out, and I'm not going to go into conspiracy here, but I think this obviously is a way to pressure the Indian government beyond just impacting immigration. So there's multiple levels to this situation. That's why don't allow yourself to be a victim. Contact us, let us talk to you. We'll create a nuanced and thoughtful solution to solve your immigration problem. I'm very confident in that. At least I'll make it better. I'll tell you what you need to do, right? So, and I'll do it very sincerely and honestly. The question here, another question that came in is, can I file an H-1 transfer petition as well as an ONA petition simultaneously? So theoretically, you can apply for any category of immigration or non-immigration that you qualify for. But you have to make a choice with respect to one or the other. You can't have both, but you can apply for both and then decide to essentially work on one or the other. Again, my concern regarding the H-1B transfer is that there's a lack of clarity with respect to whether or not it's subject to the $100,000 fee. My reading of it is that it will be subject to the $100,000 fee. So I think doing an H-1B transfer right now is probably not the best approach. I would probably wait a little bit before we do H-1B transfers at this point and make sure that clarity is provided. I think that we're probably going to wait on our end before, filing H-1B transfers on behalf of clients. That's going to be our, working advice at this point. But on the other hand, we have to look at each individual situation and make the best call. Another question coming in, what's the approval and documentation timeline for O1? Depends on the specific facts of your case. Depends on what your achievements are. Depends on what evidence you're able to present. Depends on what roles you performed. It depends on what your salary is. It depends on whether you have external evidence of, recognition of your accomplishments. Depends on whether you participated in conferences. Depends on 1,000 different things. That's why you need to probably consult with us. You can go to silmilaw.com, book a consultation, and we can help you out and assess your situation. All right. I hope that answered that question. Another question. I have an approved petition, which is an amendment, and I have a visa appointment in October for visa stamping. Is it advisable to travel and re-enter? So again, you have an approved petition, right? And you also made a visa appointment for that petition. Now, it depends on what guidance we're looking at, right? Because the official proclamation states that in your situation, you would have to pay the $100,000 fee before entering the U.S. In the clarifying comments that were made by the press secretary, it's saying that, no, actually, you don't have to pay the fee. It's saying those who already hold H-1B visas will not be charged $100,000 to re-enter. This applies to new visas, not renewals, and not current visa holders. So it's hard to say what information to believe, but in your specific situation, if you have already received H-1B approval, and so that automatically allows you to remain in the U.S. subject to your H-1B. The only reason why you would need stamping would be for future travel, right? To travel in and out of the U.S. My advice to you is don't travel. My advice is that you should probably just stay in the U.S. So this is just general advice to anybody out there. if you have visa stamping appointment, or if you are intending to travel, my recommendation is to wait it out a little bit and see what happens, because there's no clarity here, right? Even with the statement from the press secretary. I mean, even if you look at the memorandum issued by USCIS, it says that this applies to prospective petitions that have not been filed. The proclamation does not apply to aliens who are the beneficiaries of petitions that were filed prior to the effective date of the proclamation, and the beneficiaries of currently approved petitions, or are in possession of validly issued H-1B non-immigrant visas. Well, in your case, you are in possession. You're the beneficiary of a petition filed prior to the effective date. However, you're not in possession of a validly issued H-1B non-immigrant visa, because that's why you're going, is to get one, right? So, and then it says, the proclamation does not impact the ability of any current visa holder to travel to or from the U.S. Well, you don't have a visa, right? You have a H-1B extension that's issued on an I-94 by Department of Homeland Security. So, and this memorandum, by the way, is for Homeland Security, USCIS. It's not, we don't know what the State Department is saying yet. They haven't said anything. So I'd like to see what the State Department has to say before I would tell my clients whether or not to travel outside the U.S. I would wait. It's a precarious situation. So that's sort of what I would do here. And I think overall, guys, it's definitely not a pleasant situation, but we have to sort of roll with the punches here, and then do everything that we can to put ourselves in a better situation, and to find a way to overcome this. It could be a blessing in disguise. It could be the sort of impetus that allowed one to sort of get out of their waiting game and get serious about their situation. I think anybody out there, if you are in a situation where you're on an H-1B, and if you have a salary that is if you're let's just say you're in technology industry, it depends on regional bases, right? So I don't want to make too blanket of a statement, but if you have let's just say if you're outside of California, and maybe New York, but if you're outside of California and you have a salary that's $250,000 or above, that's an indication to me that we need to talk, and we could create a solution for you. It might not be immediate. It might not be like, oh, within 1 month, I'm going to file your case. Probably not. It's probably going to take a minute. We have to develop the case into one that's going to be very, very sound. If you're in California, probably more like 350 or above, particularly if you're in the Bay Area or LA. So in those scenarios, I think that, we definitely need to talk, and we definitely need to think about, what the best solution is. So for any of my existing clients, we could definitely initiate O1 in parallel to EB1. If we're already on a track where we're developing your EB1A case, it will be something that I consider whether to shift into an O1 and do a subsequent EB1. Just again, it depends on the specific situation. Like if you were already feeling really good about the EB1A, that it's going to be, close to approval, or we don't have to wait too much longer before we file, then maybe we just go with the EB1A. But if it's a situation where, there might be a lot more time building, or it might be a situation where we're not 100% sure that it's approvable, then we might look at the O1A path. Another question, is H-1B amendment filed in the future considered a new petition? Yes. Anything filed after the date indicated, which is 12:01 a.m. September 21st, whether an amendment, whether a renewal, quote unquote, whether a transfer, quote unquote, is going to be according to the statements and the proclamation issued, subject to the fee. Now, there's not even a mechanism to collect the fee. We don't know 100% what the guidance is. I anticipate there's going to be 10 more things that we learn over the course of the next week. So regarding any change to a H-1B right now, my advice is if you're in status and you're on an H-1B, hold tight. Consider O1A, consider EB1A, but hold tight on your H-1B. Don't make changes on an H-1B for at least, a week or two until we see what happens. And with that, I think I will wrap it up, and we'll definitely be out there with more information in the very short term. I was hoping to talk to you all about the October visa bulletin, but we're not going to have time for that. But overall, it was good news. I think it advanced as anticipated and expected. And they're also using the filing date for adjustment of status. Filing date for adjustment of status in the October bulletin. So thank you all. I hope everybody is, going to be able to make the right decision for themselves and their families. And above all else, please reach out and consult. It will be worth, I've never had a person consult with me and say, I really wish I didn't consult with you because, having all of this new information and direct guidance and useful strategic vision was not in my interest, so that's not going to happen. You're going to benefit greatly from a consultation. I can promise you that 100%. So please reach out for a consultation. We'd love to help you all out and get things in a better state for you. And Godspeed to everybody, and we'll be in touch soon.